Hello everyone, welcome to today's Real Estate Institute of New South Wales webinar. The topic is the main changes to the Retail Leases Act. We are pleased to welcome our presenters for today, Michael Miller and Nicola Gorton. Michael Miller is a manager and leading mediator within the Dispute Resolution Unit at the Office of the New South Wales Small Business Commissioner. Michael has a specialist focus on commercial matters and court procedure. Michael also heads the current project to deliver civil dispute resolution services to the commercial sector across regional New South Wales. Nicola Gorton is a Senior Mediation Officer. She's Office of the New South Wales Business Commissioner. Nicola has been a case manager in the dispute resolution team since 2013 and is a specialist for government agency and large organisation matters. Nicola also worked extensively on the recent Retail Leases Act review team, leading the legislative and parliamentary process of the Amendment Act. Nicola also specialises in disputes in the motor industry and has developed an expert determination process for disputes under the Smash Repair Industry Code of Conduct. This webinar is live and interactive. You are encouraged to participate by posting questions to the presenters via the chat box, which is located at the bottom right corner of your screen. If you're experiencing any difficulties such as loss of sound during the webinar, please dial 02 8267 0509. This number is also located in the chat box. I will now pass you to the presenters to begin the webinar.
Well, thanks very much for having us, REI NSW members and guests. We'd like to talk to you today about retail and commercial leases, and more generally about the role of the Office of the New South Wales Small Business Commissioner. Michael Miller is my name, and welcome Nicola Gorton as well, who has some expertise in the recent changes to the Retail Leases Act as well. So Nicola will be touching on those changes in particular, and I'll be leading you through the start of the content, a bit of the history and a bit of the context of the Retail Leases Act as well. Now, the first thing that I wanted to mention before we get underway is about our retail bond system, which we're going through a transition at the moment, as many of you will know if you're involved in retail leases. We have got a dedicated number for inquiries about retail bonds and also an email address which you can use. The number should be on your screen now. So the number for the retail bond inquiries that we've set up is 1300 153 335. And the email address for directly contacting the bonds team is weagree.bonds@smallbusiness.nsw.gov.au. So take note of those and feel free to use that number or the email address for any particular retail bond inquiries that you might have. I'd like to move on now to a little bit more general information about the Office of the New South Wales Small Business Commissioner. The main thing that we do is we provide mediation and dispute resolution services. The bulk of our work is to do with commercial leases, and in particular, that small subset of commercial leases which we call retail leases under the Retail Leases Act. So we have the exclusive authority to be doing the mediation that's required under the Retail Leases Act, but we also offer the service to any type of commercial lease dispute more generally. We also offer mediation services for business-to-business contract disputes, business-to-government contract disputes, or business-to-government disputes of any shape or form, really. But the majority of our work would be in the leasing sphere, so we have a lot of expertise there. And also we're campaigning at the moment to introduce our services to those general disputes that you might find, say, in the local court, in the general division, which is usually between $10,000 and $100,000 base claim value. We're seeing a lot of referrals from the local court. We're seeing a lot of referrals from practitioners pre-filing in the local court as well. But as your agents representing landlords mostly, I think probably the leasing area is going to be what you're most interested in. So we'll go into a bit of detail on that today. The other thing that our office does, sorry, we might have to skip back. I didn't get to dot point 2. The other thing that we do is, I thought worth mentioning, is some small business initiatives. Things such as the Small Business Friendly Councils program, and we liaise with councils to try to help them interact more efficiently with small business operators. We also have other initiatives such as the recent floods in northern New South Wales. We had a response team go up there to support small businesses. There's also some transitional arrangements for commercial fishers that you may be aware of. We assisted those small businesses transitioning through those arrangements to better understand what they were and how they could make the most out of the transitional arrangements. The other dot point you'll see up there is speaking up for small business, and that's really to encapsulate the role we have in making submissions to regulators when they may need the perspective of small businesses, but their engagement with all of their stakeholders hasn't necessarily gone into the fine detail of how the regulation or the proposal or how the market operates in relation to the small players. So we have a role in providing a voice on behalf of all small businesses across New South Wales. So the next thing I wanted to move on to is going to be the Retail Leases Act. That's the primary legislation that we deal with. And I also wanted to remind everybody that if you did have some questions that arise as part of the content, you're welcome to send them through, and we're more than happy to try to deal with questions as they arise. But I'll just start talking a little bit more about the Retail Leases Act for those that may not be familiar. It's got quite a long history. The Act was dated 1994, so the commencement I think originally was the 1st of January 1995. So it's actually been around for a very long time. There's been a couple of significant phases of the Act. So in 2006, the Act introduced the bond scheme, and another reasonably significant amount of changes took place just recently. Is in force as of the 1st of July 2017. The changes create some new obligations. They do also hope to reduce compliance costs. We might move on to the next slide there so that people can follow along. And it's essentially about governing the relationship between landlords and tenants of retail shops in New South Wales. The idea is that this Act, it's not a highly prescriptive Act, it's not a complete codification of all of the law that relates to retail shop leases in New South Wales. It's an additional layer, and the original intention was to try to give some certainty and some structure to the relationship between landlords and tenants in shops. It's seen as being a more efficient way of dealing with those sorts of tenancies, if it does have some guidelines and some structure around it. And so that's really what the Retail Leases Act looks at providing. It applies to a range of different businesses. There's a very long list, in fact, in Schedule 1. Schedule 1 of the Act, it specifically lists the types of businesses that this Act will apply to by name. It'll say, yes, a takeaway, a beauty salon, a hairdresser, shops selling these sorts of things and those sorts of things. So if you did want to refer to it, you can look it up on the internet, Retail Leases Act 1994, look to Schedule 1, and you'll see a long list of businesses to which the Act applies. The key thing is that the premises must be used wholly or predominantly for any of the uses that are on that list. It also applies to any business whatsoever if that business is located in a retail shopping centre. So the second dot point you'll have on your screen now is looking at capturing all of the businesses that might be in a retail shopping centre. So things like a mortgage broker wouldn't normally be a retail shop for the purpose of the Act, but if it were in a shopping centre, then it would be considered subject to the Act. Any business, whether it feels like it's retail or not, if it's in a retail shopping centre, it's going to be subject to the Act. And the way we define a shopping centre is essentially that there's going to be 5 or more shops that are retail shops. It's going to be known as a particular shopping centre, arcade or mall, promoted as such. It's going to have all of those characteristics of being a retail shopping centre for it to qualify. Could be an arcade, you know, you walk through, there's only 5 shops in there. It could be a major centre, your big regional catchments for the big Westfields or the other big name brands in shopping centre landlords. There are some exemptions from the Act. Shops of more than 1,000 square metres are going to be exempt. Leases that are of less than 6 months or of more than 25 years. And there are certain particular usages such as having signage rights or the $2 kiddie ride, the elephant, the zebra and the unicorn or whatever it might be. Those sorts of things, if it's a lease or a licence, it's not going to be subject to all the operation of this particular Act, the Retail Leases Act. Now, there are some key changes to the Act which I mentioned before, which were as of the 1st of July of this year. Nicola is actually our expert on that, so I might ask Nicola if you wouldn't mind running us through some of the key points and key changes.
Actually, before I get to the key changes in relation to the disclosure, there are some changes to the scope of the Act, which are worth noting. I think one of them is that agreements to lease will now be covered by the obligations in the Act, and the Act has also been extended to cover by a code permanent retail markets. So that'll be stall holders in permanent retail markets. There's always been a bit of a grey area about when the Act will apply to retailers in markets, and now that's been clarified by the Act. As Michael referred to before, there are a number of excluded premises or items or spaces really from the Act that they have been added to. There are about 16 items and they're in Schedule 1 of the Act now. And another issue that was a source of concern in the industry was the office tower exemption. That's been clarified now, so that if there is a retail business in an office tower, it will no longer be excluded by being in a shopping tower. I mean, in an office tower that's above a shopping centre. Yeah. So in terms of the disclosure of the obligations, they've been streamlined and clarified, and there've been a few amendments. Is it worth at this point talking about what the disclosure obligations are?
Yeah, so many of you will be familiar with the existing disclosure requirements. Disclosure requirements have been part of the Act for many years. We actually have a template that we make available for people if they wish to use our template. You're most welcome to do that. You can download it from our website. But a lot of landlords, if they have many holdings, or a lot of agents representing landlords, they might have their own form of disclosure, which is perfectly okay so long as it meets the requirements of the Act. If it's got the same disclosure items that are set out in the Act, it doesn't really matter what form you use. You can use ours if that's easier. You can use your own if it's got the same content. So that's been around for quite some time, and it's actually good practice, even in non-retail. We would say it's actually good practice to consider setting out some of those key provisions in any lease, be it subject to the Retail Leases Act or not. Set it out for absolute clarity. Don't leave anything to chance. So if you haven't come across that before, you might even like to look at either the disclosure requirements of the Act, or it might be easier just to review the form of the disclosure statement we've got on our website and see if that might be applicable to both your retail leases, but also possibly your non-retail leases.
So it is really important that the disclosure obligations are followed. A disclosure statement has to be provided to the lessee at least 7 days before the lease is entered into. The most significant change is that tenants now will no longer be liable for items that are not listed in the disclosure statement. There has been a lot of uncertainty about that before, and I think there have been a few cases determined in NCAT. But this issue now has been clarified with that amendment. There's also
so that was I think the agents might be familiar with pretty straightforward outgoings clauses. So you sign up to a particular rent, and you might say that the tenant is responsible, or you agree with the tenant that they're responsible for 100% of outgoings. So sometimes the outgoings clause in the lease itself is very, very straightforward. 100% of all outgoings, or 50% of all outgoings, or whatever the case might be. In the past, that creates the obligation, but then in the disclosure, typically you go through a lot of the items that do make up the outgoings. So in the disclosure, you don't say 100% of all. You actually have to go through and itemise. I think the change now is reflecting that you can't just rely on the lease to say all outgoings. Just pay for all outgoings. You actually do need to make sure that the outgoings that you want to claim are itemised in the disclosure statement.
That's right. That's right. And if they're not, and there has been an error, there is a mechanism now that the parties can agree to amend the lessor's disclosure statement once the lease is commenced. The tribunal also has broader power to make amendments to the disclosure statement and the lease as well, to give effect to the intention of the parties at the time that they entered into the lease. There's a new definition of outgoings as well, so it clarifies the scope. And outgoings, it's important when outgoings are estimated in the disclosure statement that there is a reasonable basis for that estimate. Another significant amendment is in terms of the tenant's right to termination if a lessor's disclosure statement hasn't been provided or contains information that is false or misleading. Although that right existed before the amendments, now that right has been broadened, and the tenants will actually have a right to claim compensation, and that will be for any reasonable costs incurred as a result of entering into the lease, which will also include fit-out costs. So that you can imagine that actually could be quite substantial, that compensation.
So those that have been dealing with Retail Leases Act for a while, you might know that there was the opportunity for a lease to be brought to an end if there was failure to disclose things properly. That's not that useful to a tenant because they don't really want termination. If it's something that really impacts their whole business model, then the termination isn't going to help them. So they've already committed to the fit out. They still owe the bank $200,000 and they're yet to amortise all of that on setup. So these changes give the tenants more rights for those situations where it has been a bit of a blunder in the disclosure. So you do want to make sure you get that right. I believe we have a question coming in.
We do. We have a question from Daniel Clark. So with regards to outgoings in the disclosure, what would happen if, for example, land tax became payable on the property as a single freeholding, but there was $0 on the disclosure? Can you reread that?
So I think the question is about that with land tax there are thresholds that you meet, and so it might be the case that something emerges and all of a sudden there's a liability that was not known before. Now, my view, and it's been, I don't think the changes to the Act changed the way this would have been interpreted throughout time, but essentially you can only disclose what you know at the time. You can't be expected to have a crystal ball and then predict the future. So long as you're making the disclosures based on everything you know, then that's all that you can be expected to do. Whether there's case law, I'm not too sure about case law. The legal teams will probably be able to advise you more particularly on case law. That's certainly the intention.
But I think, yeah, that reasonable basis, those words in the legislation really capture that. If it wasn't known to the landlord at the time that there was a chance that they would reach the threshold, then you know, they can't be captured. But if they did know, or there was a chance that they would, then that should be indicated on the lessor's disclosure statement to minimise the risk.
Same thing applies to all of those outgoings, which could fluctuate well, within the last 10 years anyway. There was a massive increase in the cost of insurance. Now, you wouldn't have known that going into a 5-7-year lease. You wouldn't have known that at the start of the lease. So you disclose whatever you disclose according to what last year's premiums were, or what they're likely to be in the following year. But you didn't realise that there's going to be a threefold increase possibly in the premium. So you can't just possibly disclose that. You just disclose what you know at the time on a reasonable basis.
Yeah. There's also an exemption for new statutory charges that might have come up after a lessor's disclosure statement's been issued. So if it's a provision of a lease that a tenant is responsible for the payment of statutory charges and a new one comes up, then and it wasn't, obviously can't disclose that when you issue the lessor's disclosure statement, then it doesn't necessarily mean that the tenant would not be liable for those charges. Yeah.
So very good question. I believe it's all been thought through fairly well from the legislators' point of view. And hopefully they'll be reflected in the industry practice as well as we go forward.
Yes.
About registration, should we talk about registration?
Registration, yes.
I can give you a bit of a lead into registration. So sometimes this is quite a common question that we receive at the dispute resolution unit as well. Just understanding what's the purpose of registration, why would I register, or why do I need to register, or do I need to register? So essentially the requirement to register is really an agreement between the landlord and tenant. If it's going to be a registered lease, then the landlord's usually going to be the one who takes control of the registration. And it's usually in a tenant's interest to get that lease registered. Why? Because it lets the whole world know that that tenant has an interest in that property. Now, if you look at the legal academics, they'll tell you that you really should register, if you're a tenant, you should register every lease, because even if it's only a very short time, just to make sure that you've got complete protection should the landlord change, or perhaps mortgagee take possession, or something bad happens to the landlord company, they end up in liquidation, and there's some concern about their right to occupy. So there is some default protections for short-term leases. If it's less than 3 years, then you will find the tenant does have some default protections without needing to register. But if it's longer than 3 years, the tenant doesn't have the default protections. So it really is imperative for the tenant with a longer than 3 year lease to actually insist that that be registered. So 3+ years should be registered from the tenant's point of view in all commercial leases. In the case of retail and in light of the changes, what do we have for registration?
Leases greater than 3 years, so that's in line with the Real Property Act. And there's a time limit of 3 months. 3 months after the executed copy of the lease has been returned to the landlord after execution by the tenant, the lease has to be registered. There are some exceptions that are built into the Act, things that are beyond the landlord's or landlord's agent's control that might prevent registration within 3 months. It might be time limits for mortgagee consent, or issues that arise with the LPI. And this timeline has been synchronised with the other requirement that a copy of the signed lease is provided to the tenant 3 months after it's been executed.
It's registration.
Yeah.
This is retail leases again, so it has to be subject to the Retail Leases Act. Remember, it's on Schedule 1, or it's any business in a shopping centre. It has to be subject to the Retail Leases Act. If it's longer than 3 years, it has to be registered within 3 months, unless the LPI take too long, or they take too long, and those sorts of exceptions. And it's in line with the requirement to ensure that there's a copy of that signed lease going back.
That's
so it's 3 months after, within 3 months.
And it's really, I think it's really the reason for the copy of the executed lease. It's really something that benefits both landlords and tenants, that both parties have an understanding of their rights and obligations under the lease and what's been agreed to. And I think we have a new question.
Yeah, another question. So one from John. So does a lease for 2 years and 11 months plus renewal options need to be registered?
Yes, yes, yes.
Plus options, I think, is the key.
Yes, it is the key.
Isn't it?
That's right.
So,
yes.
yeah, you add up you look to the maximum potential fixed term.
Yeah.
Might be worth just touching on what an option is as well for those that aren't super clear on it. So an option, in 99% or more of the cases in the leases that you'll be dealing with, an option is the right for the tenant to call for a new lease. They call for a new lease on the same terms as the old lease. The only things that are going to change when that new lease is provided, if they exercise their right to call for one, is going to be, well, the dates are going to change. So the first day and the last day are going to be different than the old lease. The rent is usually going to change, and it's usually going to be according to a particular method. A lot of the time it's going to be a market rent review. Could be a CPI or just a fixed increase as well. And of course the option that's just been used, you can rule a line through it. So that one has been used. But essentially, when they call for an option lease, what they're doing is saying, I'm exercising my right where you need to give me a new lease, exactly the same as the old lease, but for those minor changes, which are quite obvious. There's also a window of opportunity in which you can exercise the option, and it's usually not going to be the last day of that initial fixed term. It's usually going to be, it might be a month or maybe even 3 months before the end of the term of the lease. If they go over that time, then they lose the right to exercise the option. It's actually a window of opportunity. It starts on a particular day, it ends on a particular day. And if they don't clearly exercise the option within that window, then the option is lost to the tenant. So you do include that when you're considering the duration, the overall duration, the requirements to register. What about, now we did mention mortgagee, well, we did, mortgagee consent is actually required for registration, and that's how it links. Yeah. So I think it's an LPI requirement. Yes,
it's actually, in the context of lease preparation expenses, the Act's always prohibited landlords charging tenants lease preparations in connection with entering into a new lease, but now the Act has clarified whether mortgagee consent fees are lease preparation expenses for the purpose of the Act, and they are now. So that will mean that mortgagee consent fees cannot be passed on to the tenant.
So most of the time you're going to have a mortgage, not always, but when a lease is entered into, chances are you're going to need mortgagee's consent. You're certainly going to need mortgagee's consent before it is registered. There will be a cost. It's going to vary. Depends on the mortgagee, depends on the bank, but it is expected to be borne by the landlord. But of course, when you're negotiating, you're putting that cost and any other costs into the bigger picture of what your return on this lease is going to be over the 3 years, the 5 years, 7 years, or however long your lease might be. So you should know ahead of time what those expenses are going to be. You're going to know the landlord's legals. You're going to know the mortgagee consent fees. So you need to really factor that into the deal. We have another question.
Yes, we do. So we have a question from Lindy. So we sometimes have tenants who do not wish to pay the registration fees. They understand that it is in their advantage. In these cases, can registration be waived?
If it's an agreement that registration, it's something that is required, essentially the parties are entering into a deal. So there is that angle that says, well, you've entered into a deal here which says the lease will be registered. And if the registration, are the registration fees still claimable against the tenant after the recent changes?
I mean, my understanding of industry practice, this is not something that, I don't think the registration fees are covered by the Act, but is that the tenants usually pay for registration. And that's agreed. It's agreed between the parties, but not necessarily a provision of the lease. So it might be that it needs to become a provision of the lease so that it can be.
So you could enforce a provision of the lease if it says, we agree it's registered, but the hold up is that the tenant's not paying the registration fees, then there's very unlikely to be any sort of action that forces the registration of the lease upon the landlord when you just physically can't do it because there's been a failure to pay for fees. So that would be something which you'd run as a defence. I must say there's nothing, we've never come across that in my history with the unit where that couldn't be resolved. But an interesting, possibly an interesting sort of legal academic exercise as well to see how that might pan out. But at this stage we don't know of any case law that relates to that. And it's certainly something that we could assist with as well. Often it's just a misunderstanding. So the tenant doesn't quite get it. Maybe they're a bit unsophisticated or they haven't taken proper advice. So what you can do is you can contact our unit. You can seek advice from us. We can even offer to speak to the tenant or anybody employed by the tenant or a legal advisor working for the tenant and try to see what the actual problem is. We'd be happy to do that. Yes.
Okay, so the other amendments, moving on to assignment, the assignment provisions have been streamlined. Michael, did you want to talk about what they were like before?
So assignments, usually that's in the context of a sale of business. Now, there's a couple of ways people can sell their businesses. You may have been involved in these sorts of transactions yourself. One way is that a company exists and somebody else just buys the shares in a company, and then it's an acquisition by share purchase, essentially. And it's unlikely that you're going to have too many ramifications for the lease because it's a company as a tenant and there's just a share transfer. You may have certain covenants in your lease that say, oh, well, if there's going to be a change in who controls the company, then we need to know about it or we need to grant consent. But the classic model is that the lease actually is being transferred. So the lessee comes off, the old lessee comes off, and the new lessee comes on. So there is the possibility that you can do it under the Retail Leases Act. There's a certain framework that you can go through. It's usually going to be the tenant that's pushing it, and they're going to say things like, well, we've got a proposed buyer and a proposed assignee, so a new person. We're going to provide you the financials and a bit of the background for this tenant, and we're going to seek the landlord's consent, which is usually required. If they do it in accordance with the Retail Leases Act, they have a time frame in which, so the landlords would have a time frame in which to respond to that and say, yes, we agree, or actually we've got some concerns. Usually tenants are going to want to use that when they can demonstrate the new person has the same or better retailing skills and financial resources. And the benefit to the tenant of doing it is that it puts a timeline on the response from the landlord. If the landlord doesn't respond, they can push for deemed consent. So in the absence of saying yes or no, if I can show you that there is a good new tenant coming in, I'm going to assume that you have, or it's going to be deemed that you have consented, and we'll rely on that assumption. And they can also get a protection from liability going forward after the assignment takes place. So by using the Act, the tenants do have some advantage. In practice, it doesn't always happen under the Act. In practice, quite often, it's just a negotiation, and the lawyers might deal with it by way of a deed of assignment. They may provide an assignor's disclosure statement. There might be an assignee's acceptance of that disclosure statement, but it may not always utilise the provisions of the Retail Leases Act. Sometimes it is just simply done by agreement. That's the background. That's the way it's been for some time. What about any key changes?
Well, excuse me. One of the key changes is there's an additional reason. I think the Act outlines a limited number of reasons why a landlord could refuse consent, and there's another reason that's been added to that, and that's if the incoming tenant, the assignee, doesn't meet a public tender requirement. So obviously if that would be in a scenario where a lease was put out to public tender. Now that's probably not going to affect a great number of people. That was really contemplating government landlords who offer leases like that. And another significant change that has actually sought to clarify an area that's been a big source of dispute in relation to assignments is the point in time when a landlord makes those assessments about the retailing and financial standing of an incoming tenant. There was a lot of dispute about whether the point in time when the assessment should be made was when the sitting tenant first entered into the lease, or when at the point in time of the actual assignment. Now the Act actually clarifies that it's actually at the point of assignment. Now whether that's going to be a benefit or a disadvantage is really going to, it swings and roundabouts. It's really going to depend on the circumstances.
I think you'll find that most of the time you are doing it based on just a negotiation and a deed of assignment ultimately. So we see in practice, whilst there is some leverage for the tenant to push certain timelines to be met, it's most often going to be just a deal that's made, and it doesn't necessarily rely upon interpretation of provisions of the Act. So certainly keep your deal-making hats on and keep things in mind when you're assessing. We'd say, just simply don't be in a position to refuse anything on site. Certainly look at your due diligence, look at the sort of costs that may go to the landlord and the certain risks that might pass through to the landlord. There's no obligation on the landlord to accept higher risk or to accept the costs. That's all protected under the Act, and you should also be doing that when you're doing any negotiations about assignment as well. Now, I just wanted to check, was there any other questions in relation to that at this stage? I wonder if we should move on maybe from some of the changes. Any other key changes that we should address?
With return of bank guarantees, should we mention that?
Yes. You see there's a few dot points there which we may not have gone into great detail on all of them.
But should just note with some of the amendments that there are some of these new amendments particularly are actually penalty provisions. So compliance is definitely encouraged.
What's our next slide on this one? Let's have a look at some of the other dot points. Go back one. Okay, so online sales. Okay, that means that you're not asking the tenants to account for their online sales.
Yeah, as a component of turnover rent, they have to be connected with the bricks and mortar store in some way. That's basically like landlords are prohibited from acquiring them unless they're connected with the bricks and mortar store. The increase in the jurisdiction of MCAT should see a greater number of matters being able to go there, better access to justice, and I think that really contemplates the average cost of a fit out and annual rent. It's more in line with that. And of course, yeah, the valuer, the retail valuer appointment process has been transferred to the Office of Small Business, which is an administrative process, and that's really done for efficiency and quality assurance.
And maybe just a quick rundown for retail leases in terms of the agents out there. What do you need to give a tenant? What's on your high-level checklist? Next slide gives us a couple of dot points to refer to there. So you should have a copy of the proposed lease available. There will be negotiations always, but you should at least have a copy of what the landlord's proposal would be. We would say that you should have the retail tenants guide. You must have the disclosure statement 7 days before. And the other dot point we just wanted to raise is that keep in mind the lease under the Retail Leases Act starts when the tenant takes possession, starts to pay rent, or executes the lease. And that's a little bit different to some other property transactions where the general law sort of says, well, if it's a dealing in property, it must be in writing. But you can actually start in terms of a retail lease, not just when you've got the written document executed. It could be that possession is granted, or there's a payment of rent as well. So a little bit different to just the normal property dealings. What else do we have there? What do you need to provide the tenant annually? You want to take us through some of those dot points?
So, well, these are requirements of the Acts. The annual estimates of the outgoings, and and then this is reconciled with the actual expenditure. The audited outgoing statement is only applicable for so there are certain outgoings which are very easily able to be demonstrated, things like rates notices and insurance premiums that come from the big insurer. You are not necessarily going to need an audited statement on every lease that you might manage. You will need it if the outgoings cover more than just what we call the statutory outgoings, because there's a little part of the Act which says if it is just this, this, this and this, then you don't need an audited statement. So the simple things, the rates notices and water and that sort of thing, and land tax, you don't need an auditor. But if it was to go broader than that and say, oh, there's management fees and there's gardening services and child minding that you pay a proportion to, or whatever the other case might be, more typically aligned with shopping centres, big and small, then there will be an audited statement required as well. But it's not a change. This has been around for as long as the Act's been around. Accounting for any marketing plans, again, more relevant to a shopping centre.
There is also worth noting, and this is not a change, but it's been around forever, prior to the end of the lease, there is meant to be a notice of intention sent out. So 6 months before the end, you'll be saying, we're considering offering a new lease, or we're not considering offering a new lease, and you'll be proposing terms. If you don't do that, then it just allows the tenant a little bit of extra time from when you do give that notice of what you intend to do at the end of the lease. It might be as simple as saying, look, here's a notice that says we are willing to negotiate new terms for a new lease. Or it might be as simple as saying we're just simply not interested in a new lease. But the 6 month clock effectively starts ticking from when you do give that notice, which allows the tenant up to 6 months to arrange their affairs, move out essentially, or make other arrangements for a relocation.
Yeah, so effectively not doing it, presumably you're extending the lease, really.
Yeah, you're giving a few extra months on a fixed term. Yeah, if the tenant wants and needs that. Do we have a question?
We do have a question. So, can you provide a tenant a copy of the disclosure statement and the lease at the same time, providing it's given 7 days prior to the lease commencement date?
You can. You might have a disclosure statement that's prepared well in advance. Of course, sometimes there are negotiations surrounding outgoings, and that may change the nature of the disclosure. There might be other things that emerge. But the key requirement is it's meant to be provided 7 days prior to entering into the lease.
Yes. And it should be noted also that agreements to lease will also be required to provide lessors disclosure statements at the time that agreement to lease is entered into. And there might be, depending on how far out the agreement to lease is given before the lease is entered into, there might be changes in, since the estimates were given. But there is a mechanism where the parties can agree to amend the lessor's disclosure statement.
Some good questions coming through.
Thanks, Kate.
People are paying attention. Now, I think we should probably move on to talking about a bit more general things. So I was just going to touch on commercial leases more generally. We've talked a lot about retail leases, and it is a large portion of the work that we do. But generally speaking, with commercial leases, remembering that retail leases are a subset of commercial leases. Commercial leases could be office space, a farm, a factory, some sort of industrial site, anything that maybe is on a strip or it has shopfront retail, but maybe it's not a Schedule 1 type of business. Generally speaking, you just call that a commercial lease. The main sources of law, if you like, that are going to apply to these things is the lease itself. Parties are pretty much free to enter into whatever sort of contractual arrangements they like surrounding the use of the property. There is no specific act that covers commercial leases or any of those other particular forms of commercial lease. Really, there is the Retail Leases Act for that small subset of commercial leases, and just the general law applies to everything else that's commercial. Things like Conveyancing Act, you might have notices that need to be provided, and that Conveyancing Act applies to retail and it applies to commercial leases generally. The Real Property Act typically deals with the registration issues, so that applies to retail, and it also applies to commercial leases generally. And of course, the interpretation of the courts over time, precedents that are set by various court decisions, they help us interpret what the clauses in a lease might have meant to be, or interpret any legislation that might apply as well. So that's kind of a broad base of where you go to find out the answers to things. As agents, you probably find that you don't always have the answers to everything, and it's a bit too hard to go and look everything up yourself. So often the finer point questions are going to refer to lawyers. They may have existing experience, so they sort of know the answer off the top of their head because they've done it. Or if they don't quite know it, then they do have the ability to go and do the research and then provide an opinion about how the law might apply to the particular situation to hand. So whether it's commercial, generally speaking, or retail, all of those things still apply. I also thought I'd talk a little bit about some of the transactional matters that you might be faced with. There is a bit of paperwork involved, or if you're moving electronically, it'll be PDFs or some other electronic form of a paper document. But essentially, I use the heading paperwork to describe things like the proposed lease. There's going to be preparation costs, and there's going to be legal accounts, and there's going to be registration fees and all that sort of thing. So various forms to fill in. If it's going to be registered, it has to be in a form which is acceptable for registration. And some forms of lease, particularly the shorter term leases that you'll find, they aren't going to be in registrable form. You've got the disclosure statements we've talked about. And I also said earlier that you may even choose to make certain disclosures just for clarity rather than leave things to chance or to misinterpretation, whether it's retail or general commercial. There's retail tenants guides which are available and also useful to inform. They help you to inform the tenant if they're a bit unsophisticated, they're not getting adequate advice. Tenants can freely get those themselves, but it sometimes also helps in the negotiation and the understanding of what a commercial lease is to be able to provide those sort of guides. The other thing I've mentioned to consider is condition reports or dilapidation reports. Be very familiar with them if you do residential. But they're also quite okay to use in commercial. It might be the case that the make good requirement is very different to what you might find in a residential tenancy. And it might be that you do want to make a note of certain things, the condition of certain things at the start of the tenancy, if the make good needs to be referred back to the start of the tenancy, or even if you just want an accurate record to try to alleviate that risk of having disputes down the track. I'll also talk a little bit about security for these leases. Now, the classic is you take a bond. It's a cash bond. If it's the Retail Leases Act, then if you take a cash bond, there's going to be a requirement to lodge that in the retail bond security system, which we manage. You can also take a bond for a non-retail lease. That's a cash form of security. It doesn't have to be X number of months or weeks. It could be any amount that is agreed by the parties. So in some cases you might say, we'd like to get 6 months worth of rent as a bond. In some cases you might say, let's just call it $10,000. In some cases the tenant might come back and say, look, I can't afford that. I'm just a startup and I can afford to give you $2,000 or 1 month's worth of rent. There's no restrictions on what you can agree to in terms of the amount of any cash security. I'll also mention at this point in time holding deposits, because that can be a source of confusion sometimes. We see a lot of disputes arise when you just use the term holding deposit, but you're not very specific about what it's actually meant to be doing. Is it meant to be refundable? Is it meant to be non-refundable? Is it meant to be applied to the first month's rent if you do go ahead? Is it meant to be refundable if a DA is not approved? Is it meant to be applied to preparation expenses incurred by the landlord if the tenant doesn't go ahead? Is it some sort of an option? Is it some sort of a right that says you must take the property off the market, not show it to anybody? You've got my holding deposit, therefore you've got to take it off the market and give me the right to take it or leave it and forfeit the holding deposit if I choose to leave it. But without knowing the detail of that, then you may find you get into disputes when there is something unexpected arise. So we would encourage you to be fairly accurate in your description when you say, look, this is to do this, this is why I'm taking the deposit. Be fairly accurate in that, so you've got a reference point if there is a problem later down the track. I think we might have a question on bonds or holding deposits.
Yeah, so just on bonds. So if a tenant advises they cannot afford the requested 3 month bond, are we able to place provisions in a lease to extend this throughout the lease to eventually equate to 3 months rent?
Yeah, people do that quite a bit actually, and you can top up a bond as well. So you might take a month, and then in another month's time, or no, 3 months' time, there's a further month that's due. When you get it, if it's retail, you can top it up in terms of the lodgement. I should also mention that you may be managing commercial, so general commercial but not retail, and wondering what to do with the bond. If it is a lower value bond, you might like to use the retail scheme to manage that bond. You're most welcome to. There's no prohibition on lodging other types of bonds in the retail bond scheme. People do it just for their own, because it's easier sometimes, it's quite okay. But if it's non-retail, you don't have to. So you can manage it through other means. Bank guarantees are worth talking about as well in this context. So a bank guarantee is usually going to be a bank providing an undertaking to pay the landlord on demand. All you need to do is show up with a bank guarantee and say, I'd like that amount of money, please. Bank doesn't ask any questions. Typically very good for the landlord to have a bank guarantee. Often it's going to be secured by the tenant having a term deposit with that bank or some other facility securing the amount. So there's no problem with you having a bank guarantee. It's just a question of negotiating that with the tenant. You don't lodge it. If you have a bank guarantee, you don't lodge it with us if it's retail or non-retail. It's just simply a piece of paper saying, us as the bank will pay you as the landlord if you ask us to pay. It's also personal guarantees. So with commercial tenancies, often there are going to be companies involved, and usually the landlord is going to say, well, I'd like to see a personal guarantee because the company might not have significant value or assets that attach to that company. So often they will be in the form of a director's undertaking. It might be a page in the lease where a director has personally guaranteed the performance of the lease obligations. Now, if you're a legal advisor advising a landlord, you're always going to say, don't enter into a lease with a tenant who's a company and not get a personal guarantee. But of course, the advisors advising the tenant are always going to say, don't give any personal guarantees. So this is just an issue where you can negotiate to find what is a satisfactory level of security given the market, prevailing market conditions. Thought I'd also talk a little bit about risks. Now, when you're assessing tenants, you're going to be looking at business structures. If it's a proprietary limited company, you're going to be saying, well, what is there an asset backing for this, or is it essentially just a vehicle that's been set up to handle the lease, and if it doesn't work out, then we are limited in how much we can recover. You might be limited in terms of a cash bond, you might be limited in terms of a bank guarantee, you might be limited in terms of the personal guarantee if there is one. That person might not have any asset backing. So we would encourage you to consider the business structures when you're entering into the lease. Who is it that's entering into the lease? Is it a company? Is it a sole trader? Is it a partnership? Is it a corporate vehicle on behalf of a trust? When you think about these structures, it's not just how the name looks on the plaque out the front of the business. What you're actually doing is you're considering, well, what's the potential recourse in the case that things go awry, and what can we get in the prevailing market? If it's not a great market for landlords, then you may not have the ability to get all of the security in the world to secure the obligations for 5 years, no doubt about it. You may be having to make some compromises. But we'd say keep that in mind so there's no surprises. That connects to the next dot point, which is about diligence. You'll be wanting to assess the tenants available as best as you can, asking them maybe to say, well, how long has this company been around? Who are the directors? You can get a lot of this information that's publicly available. You can rely upon submissions from the tenant as well when you're assessing. But obviously, you do your best with the information you have to hand. Keep in mind there are public registers for companies, and that's quite a common vehicle that goes on as a tenant in a lease. And it might be that the tenant's doing the same for a landlord entity as well. Local conditions can be a risk because you don't have a crystal ball yourself. You don't know if there's going to be significant changes in the local area that are going to affect this business. Many years ago, if you're around in North Sydney, the Optus building emptied out because they relocated to another part of the world. So that meant that all of the tenancies, the retail tenancies, were impacted by foot traffic. Basically, there were no more Optus employees coming to buy the coffees or whatever they were doing, which impacted those tenancies, which in turn impacted the landlords. The deals were struck with a particular view in mind, but not knowing that the Optus building was going to empty out. So changes to local conditions can really impact essentially the potential yield and the outlook for that particular square meterage that you're leasing. And there's also broader economic conditions that you do your best to try to predict, but you don't always have that crystal ball. So if employment's not as good or wages growth aren't as good, and that translates to lower spending across the threshold of the retail business, then your landlord might find they're under pressure as well. You do your best to assess all these risks. If things do come to fruition that you were hoping they wouldn't, keep in mind that our service can give some advice both to landlords, agents, representing landlords, and also the tenants, and we offer a mediation service that can try to help you adapt as best as you can to the changing conditions or anything that's unexpected. I'll talk quickly about finishing up a lease. Usually you're going to want to have a notice ready. If the lease is going to finish up, you're going to have an understanding of what the landlord's expectation is about make good. It should be detailed in the lease what the make good requirements are. You may need to revisit it. It might have been many years, and make good can vary from lease to lease. So do pay attention there. You can end leases early by agreement. So if a tenant wants to disappear and there's an opportunity maybe to do any redevelopment or re-tenanting, and it's a few months or even a few years out, you can do it by agreement. A tenant can surrender a lease. It might be that the tenant's coming to you saying, well, can I buy myself out of the remainder of the lease? It might also be that the landlord's coming to the tenant saying, can I buy you out of the remainder because I've got a better offer, or I've got a development I want to take and I don't want you to be here that long. You can also end early by re-entry, and typically that's when there are some breaches that can't be remedied or haven't been remedied. Typically there's late rent payments. So you can end a lease by re-entering and then see what the tenant owes and ask them to pay it. What you'll typically find is they've gone early or they're not able to pay the rent because of some of those risks that we identified in the last slide, and they may not have the money to pay for everything. You can claim the bank guarantee, you can look to personal guarantees. But again, in these situations, I do want to make it clear that we're available to give advice. This is retail or commercial, it doesn't matter. If you're a landlord / agent representing landlord, or if you're a tenant, you can contact us for advice about how this might work in your particular circumstances. And we do have a mediation service that can help. So, the dispute resolution unit, call us or email us and we'll be certain to get back to you and help you through or answer it on the spot if you can get us on the phone on 1300 795 534. So you can call that. It's where we've got plenty of people during business hours to answer any queries you might have in more detail. We've also got an email address. You're welcome to send any of your general inquiries through to we.assist@smallbusiness.nsw.gov.au. Now we're getting close to the wrap up, so I did want to leave time for any other last minute questions before we have to wrap up the webinar. Thank you for your attendance.
So we do have two questions. So one from Judy Wilson. So a landlord has a lease prepared for a retail lease. The tenant pulls out. Is the landlord able to claim his legal costs out of the holding deposit?
It would be wise to say before you take that deposit, okay, so if you pull out, we want to take part of that deposit or all of it potentially to offset any legal expenses. So if you make it clear, that's going to save a lot of hassle in the longer run when the tenant says, oh yeah, but this and but that and but this, all these things happen.
Yeah, ideally something in writing.
Yeah.
Something in writing.
Yeah.
So it's very clear.
Make it very clear. You might have some pro forma sort of template things that you want to use, but at the next best thing, I suppose, is to write it on the receipt, at least a few dot points and circumstances, rather than just go HOLDINGDEPOSIT. Let's have a little bit more detail, and that will help you to deal with that if that does eventuate.
Thank you. So thank you for the question, Judy. So another one, so I do apologise if I'm pronouncing your name incorrectly, Apurus Sotan. What happens when the outgoings are more than the one from last year?
You can update as you go.
Yes,
so
and you do that anyway. There is that mechanism in the Act. In terms of the lessor disclosure statement, that is really the outgoings. You're estimating the outgoings for the first 12 months, but the Act itself has that mechanism whereby you're estimating annually, and you would expect that there are fluctuations.
So you're going to account for outgoings one way or the other, even if it's just show a copy of the invoices. It could be show a copy, it could be an audited statement, but then there's also a projection for the next year, and usually it's easy to know because you can see the bills that they're coming in.
So we do have another two questions.
Oh,
Question from Maria. So it's a question regarding tenants selling a business and passing on lease costs.
So usually the tenant is going to wear all of the costs associated with the assignment of a lease. Well, either the tenant coming in or the tenant going out, but they're going to work it out between themselves. So there's no expectation that the landlord pays for the transfer of lease. Landlord goes into a lease, they expect that the person they're dealing with stays for the term of the lease. If the tenant wants to assign, they may have rights to assign by lease, by statute, they can do it, but there's certainly no expectation that the landlord has to lose anything on that transfer.
So she's added to that. So what about if they want to do a new lease?
So yeah, new lease, you can do it by new lease. You would be making a decision whether you want to do a new lease or not. And sometimes it is in the landlord's best interest. So if it's a retail lease and it's a new lease, the landlord does have to wear those lease preparation expenses, but it's a new lease, so you can reset the rent. You're not bound to the old rent or the old terms. You can change those terms as part of any new lease.
So can you charge a lessee though?
If it's a new lease and it's a retail lease, you cannot pass those expenses for lease preparation back to, well, it will be the new tenant, I suppose. But what you're doing is you're able to renegotiate the entire term, so you're going to amortise those costs, $3 grand or whatever it might be, over the course of the balance of the lease.
But I think there's an exception if there are significant changes that are being made to the lease that's being signed, called for by the tenant, then we would, in that scenario, we would expect.
Right. Yeah. So you can assign, which is just give the balance of the lease.
Yeah.
That's one thing. And the landlord doesn't have to wear the costs of assignment, essentially, right? So that's just transferring the balance. But if it's a completely new lease, then that's a very different situation. The old tenant is possibly off the hook altogether, and one tenant surrenders the old lease and a new tenant takes over. Now, you could deal with it in terms of, well, if you're surrendering the old lease, what's the deal? Why should we let you surrender? What are the terms of that surrender? And then the new lease is going to be subject to the provisions of the Act if it is a Retail Leases Act lease.
So we have just gone over a little bit of time. So do you have a little bit of time to answer 4 more questions? Or am I pushing it?
See how we go.
All right, we'll be quickly. So Catherine, so what charges are involved for your mediation services?
You can contact us on the phone and talk to us, or by email. There's no charges for that. You can file an application with us. It's just a form. You tell us who you are, who they are, a little bit about the dispute. It costs you nothing. We'll contact the other side and we'll say, hey, listen, we've got an application for mediation. Can we set something up? Do you want to go back and talk to them privately? That's okay. Do you want us to be a bit of a go-between? That's okay too. We can manage it from the desk. If we set up a mediation in a room, we'll book a room. It might be wherever you happen to be in a major sort of locality, or it could be in the CBD in Sydney. And we appoint one of our mediators. Then we're going to ask both parties to cover $152 per hour per party. So that's the cost at the end of the day that you pay us, which is essentially the mediation fee. So it goes to the mediator, but we cover the cost of the venue, any transport requirements for our mediators, and we cover all of the case management costs, anything in relation to that from our office. All you need to know is $152 per hour per party.
Perfect. Thank you. So one from Caitlin. So when will the new bonds online be available for retail bond lodgements, as we can't see your bonds at the moment?
I'll have to get back to you on that. That's with the bonds team. So we're the dispute resolution team, so we'll answer any general inquiries. You can call us on that 1300 795 534. We did, maybe we could flip back to the bonds slide in case anybody missed that at the start. So we do have a bonds team set up, ready to go with any inquiries there as well.
Okay, so sorry guys. So a question from Daniel. So if you had to take possession of a retail property due to non-performance, etc., what are a lessor's obligations with the remaining items or stock in an instance where the tenant has disappeared or arrangements cannot be made for the removal of the items by the tenant?
That's a big,
Get that a lot.
Big question.
You might want to call us. Look, one thing you've got to check is who actually owns this stuff. Is it of any value? It might be, if it's a coffee machine, it's on lease, so there's a finance company that actually owns this, and you're not entitled to it because it's not owned by the tenant, it's not owned by the landlord. So it might, a Coke fridge and things like that. Ultimately, they'll probably end up having to go back to whoever it is that owns them. But there might be, some businesses, they have customers' things. I'm doing shoe repairs. You can't keep the shoes, late nights. So you can't keep all those sort of things. Usually you're just going to put a notice on, if you need your shoes, please give us a call and we'll happily give your shoes back. there may be the ability to, if some leases have a structure where you can take possession and take ownership of certain things.
Yes.
It's a classic thing where you want to ring us up and we can help you out in more detail in each circumstance because there's such a variation.
Yes.
One more question.
All right.
So, Georgina, so if a lease is assigned and varied, does the assignee or assignor pay for the cost of the variation?
Yeah, so that was what
That was
referring
what,
to.
yeah. So it would be the tenant, the incoming tenant, are going to really have to.
Yeah.
If it's
their variation.
If they're calling for the variations, then yes.
And they're agreed to,
Yeah.
because you don't have to agree to variations. There can be just simple negotiations that take place. Might be a variation that the landlord wants, in which case the tenant might say, well, if you want a variation to benefit you, then maybe we need to talk.
I'm so sorry, guys. One more question. It's just come through, Maria. So if a tenant of a retail lease sells their business and the incoming leasee wants to sign a new lease instead of assign an existing lease, can you on-charge lease cost?
To the landlord or to the...
So if you're an agent and you're managing this, and I think what you're saying is, okay, so there's a sale of business. Really, if they're talking about selling, they should have been probably talking to you already. If they're going to sell it and there's a new lease, the new lease in a retail context, Retail Leases Act, there's a prohibition on lease preparation expenses. There's a prohibition on lease preparation expenses. It's a new lease, so you can't charge it. But if they're going early, then there might be a question of, well, why should we let you out of that lease, and can we come to terms on the surrender of the old lease? Or perhaps if it's wound up at the end of its tenancy at will, then the landlord is at least in a position to renegotiate the terms of that new lease. And if it is going to be very onerous, there's a lot of money involved, then probably what the landlord's going to do is they're going to seek an adjustment of the rent, because they're not bound to the old lease's rent. It's really subject to the prevailing market conditions. And usually if it's a sale of business, then that tenant, the new tenant, really wants that premises. So they'll probably agree to a variation in rent, for example, which might account for the whatever, it's usually fairly small hit to the yield that the tenant will get under the new lease, the landlord will get under the new lease over the entire term of that new lease. So $3,000 worth of prep expenses over 3 years, so $1,000 a year. You try and negotiate it up to another $1,000 over what it otherwise would be. And you square on the yield. Depends on the market, though. If it's a bad market, you'll have to take the hit, or if it's a good market, you can go even further.
Thank you very much. So I guess that's it. So
great.
We're wrapping it up
thanks
now.
for having us. Hope you enjoyed the webinar, and happy to talk further. If you want to call our dispute resolution unit, 1300 795 534 is the number, or the we.assist at smallbusiness.nsw.gov.
Thank you very much for our presenters today, Michael and Nicola, for joining us. I'm so sorry for everyone. We have gone slightly over time, but thank you everybody for your patience, and thank you for participating on our webinar, the main changes to the retail and commercial leases. So please complete the survey at the end of the webinar as REI NSW values your feedback.